So let's take a closer look at the powers of the presidency. Where do those powers come from? So, just as Congress has both enumerated powers and implied powers and inherent powers, the president also has what are called expressed powers and inherent powers. So, expressed powers are the ones written in the Constitution, and inherent powers are those that are implied by the fact that he's been given the executive power. There's a third category as well, and that is statutory powers. Powers that have been given to the president by Congress. That in acting legislation, Congress has then given the president the power to interpret through regulation certain provisions that they have not spelled out concretely in the legislation. There are also some additional sort of special powers that have emerged that come up from time to time. Things like an electoral mandate. Sometimes you get an election where there's just a particular issue that a candidate has run on that was really the whole focus of their campaign. And so then it is interpreted, if they win, it is interpreted that this is a statement about people really wanting that policy to be pursued. It's called a mandate. In general, the more popular a president is, the more powerful that president is. And the more unified public opinion is behind a president. But then there are also certain powers, like emergency powers, that have come about through practice and tradition. So, starting with the most concrete, the Constitution, the expressed powers, these are laid out in Article 2, which sets out the presidency, and that is especially sections 2 and 3. There are also the veto power is actually in Article 1, because that is a limit on the legislative power. So, but in Article 2, you get the president as the commander-in-chief of the armed forces, the power to appoint the executive department heads, ambassadors, Supreme Court justices, and people to fill certain vacancies in the bureaucracy, the power to grant pardons, except in the case of impeachment. And that exception is based on the fact that an impeachment is not a legal trial. It is a person who's being impeached is not going to jail if they're not subject to losing their life, liberty, or property if they are found guilty. What they're facing is removal from office. They may then, if their actions were criminal, face a criminal trial, but for which they could potentially be pardoned. So the president can pardon for crimes, but cannot prevent someone from being removed from office through the impeachment process. Another area that has not ever been tried is whether a president can pardon himself. We may find that out, but so far that has not yet happened. We have, however, in the case of Richard Nixon, had a precedent where the president resigned, the vice president became president, and one of Gerald Ford's first acts as president was to pardon Richard Nixon for any crimes he may or may not have committed. So it spared the country, the logic was it spared the country going through the trial and possible imprisonment of a president. It doesn't mean that Nixon necessarily committed any criminal acts. Criminal acts were definitely committed during the Watergate scandal, but Nixon wasn't part of those, was not even necessarily, as far as we can tell, aware of them. What he did take part in was the cover-up afterwards, which may or may not have been illegal. We won't know. There wasn't a trial because Ford pardoned him. So that we have a precedent for. The Constitution grants the president the power to enter into treaties, but requires 2/3 consent of the Senate to ratify treaties. So the president has the power to negotiate the treaty. the president is required to report annually on the State of the Union to Congress. This is a joint session of Congress, so the House and the Senate together, and it has taken the form of an annual speech given to Congress. That is, since the advent of television, is televised, the State of the Union address. The Constitution only requires, though, that the president report on the State of the Union to Congress. It could be a written document if presidents wanted to, but again, so much of the president's power is through his ability to get public and media attention, and so any opportunities to get that attention are not to be passed up. So they make it a televised speech. The president has the power to convene Congress, to receive ambassadors of other nations, and to commission all officers, all military officers in the United States. Article 2, which creates the presidency, the executive power of the United States, is much shorter than Article 1. And that leaves some space for interpretation, and that's where inherent powers come from. So the so-called Take Care Clause states that, quote, the executive power shall be vested in a president of the United States of America, and that person, quote, shall take care that the laws be faithfully executed. So you've got the executive power, you've got those listed powers, but then you have this executive power that is supposed to take care that the laws be faithfully executed. On that basis, presidents have argued successfully that they therefore have powers not listed that are yet nevertheless necessary in order for the laws to be faithfully executed. So, for example, one case involved in this was having to do with a railroad strike. And the president issued, there was an injunction issued at the request of the president to end the strike. Railroad workers have to go back to work. And one of the union heads refused to end the strike, ends up charged, and challenges the injunction. The Supreme Court ruled that because the government has the responsibility to regulate interstate commerce and to see that the post office is run to deliver the mail, and at the time the railroads were an important part of the mail delivery infrastructure, that you had the inherent executive power to make sure the railroads run and therefore could order the end of the strike. So the inherent powers are not expressly granted anywhere in the language of the Constitution, but they are powers to take the actions necessary to execute and enforce the laws. And then the third category, the statutory powers. These are powers that have been explicitly granted to the president through legislation. So often that will take the form of legislation regarding, say, the environmental protection. You have legislation that outlines in general terms what Congress wants, but then leaves to the executive departments, to the EPA, the ability to fill in the details with appropriate regulations. So that is then granting the president and the executive offices the ability to fill that in. So that is statutory power. And then there are these special powers. These come from various sources. But they're basically, they've evolved over time as traditions that are now accepted as powers that are inherent in the presidency, that belong to the presidency. And people are no longer arguing over whether they exist. They may still argue whether something a particular president wants to do legitimately falls under one of these powers. So they are the issuing of executive orders, emergency powers, and executive privilege. Let's look at each of those a little more closely. So executive orders are orders from the president to the executive departments about actions they either should or should not be taking. So they direct the enforcement of congressional statutes or Supreme Court rulings, enforce specific provisions of the Constitution, guide the administration of treaties. So the president is telling the executive departments how they ought to enforce things. This can be very controversial. Some are very controversial, a lot are not. This is basically the president sort of stepping in and personally directing those executive departments. Some very sketchy things have been done, and others that were very popular. They give the president a way to act when Congress either can't or won't. So one that was extremely controversial that I think in hindsight is we all regret is Executive Order 9066. That was the one that allowed the internment of Americans of Japanese ancestry during World War II. That is one for which subsequent presidents, President Reagan, subsequently apologized. It was FDR that issued that executive order. Decades later, Reagan apologized and Congress approved some reparations to those people for property that they lost while they were in the internment camps. An example of one that is more popular, President Obama issued DACA, which created the Dreamers as an executive order. So that was an instruction to immigration services not to go after undocumented children, to not pursue those. It didn't change the status of the Dreamers, but it said not going to actively enforce this. The advantage of executive orders is it allows presidents to tackle issues that Congress is not tackling, like immigration reform. That's where DACA came from. Or to address emergency situations, which is how Roosevelt felt was going on with the internment of Japanese Americans. The downside of executive orders, like the downside of any unilateral executive action that's not within, defined as the president's, enumerated in the Constitution, is that the next president can just, with an executive order, wipe them out, which is what President Trump tried to do to DACA. And President Biden is probably going to do to a lot of what President Trump has done through executive orders. So executive orders, like executive agreements, like all of these things that presidents have, that have evolved that have given presidents more power, but without the buy-in of Congress, they're very easy to change later. They don't. Well, if a president can do it unilaterally, another president can undo it unilaterally. Emergency powers. These are powers that a president exercises during times of national crisis. First done by Abraham Lincoln when he suspended the writ of habeas corpus during the Civil War, claiming emergency powers. The Supreme Court has since acknowledged that something like it does exist. That the president can, in emergency situations, when dealing with external affairs, have more latitude than would be permitted if it was dealing with things inside the country. So the case that is mentioned here, the U.S. v. Curtiss-Wright Export Corp., where the Supreme Court acknowledged the existence of emergency powers. The situation was the Curtiss-Wright Export Corp. Is an arms manufacturer. They were selling weapons to Bolivia. And Bolivia was involved in a dispute with Paraguay at the time. There was a joint resolution of Congress, as well as a proclamation by the president, saying that nobody should be selling arms to either side of this. The president was trying to help resolve the situation, and they didn't want any Americans involved in upping the tensions. Well, the Curtiss Wright Company challenged that, violated it, and ends up being charged with that violation. And the Supreme Court, their defense was that Congress was delegating too much power to the president. That the Congress can't delegate legislative power to the president, and that by allowing the president to make this proclamation, Congress was unconstitutionally delegating its authority. The Supreme Court ruled that since this was dealing with diplomacy, since this was dealing with matters of foreign policy, and the president is the only one the Constitution enables to engage in foreign policy, Congress doesn't have that power, that Congress giving the president more latitude in this area was permissible, and so that the president did in fact have this latitude to exercise emergency powers. Finally, executive privilege. This is sort of like attorney-client privilege, if you've ever heard of that. If you talk to a lawyer, your lawyer cannot be compelled to testify in court what you have said to them. So the rationale behind that is that in order to provide the best defense for someone, you have to be able to confide in your counsel. So even if you can admit to your attorney that you're guilty, that you did it, they can't disclose that. Even if they want to, they can't disclose that. Executive privilege is a similar idea. The idea is that the president needs to be able to get the best, most candid advice if he's going to be able to make good decisions. So people speaking to the president need to know that the president can keep things confidential, so that they will give their best, most unfiltered advice. And so the president and other the executive officials can refuse to disclose information that from confidential conversations or things related to national security to Congress or to the courts, so that they can have the advantage of people's unfiltered thoughts. In general, courts have upheld this if it's really about a separation of powers. If it's really about Congress or the courts trying to meddle in the president's domain, then claims of executive privilege have been upheld. The place where they've limited them is when presidents have tried to use executive privilege to hide potential misdeeds on the part of the executive branch. So, for example, Nixon had the Oval Office wired with recording devices because that technology was relatively new, and he thought, quite rightly, that history will be interested to know what happens. And so he was recording what happened in the Oval Office verbatim. Also, he had records. The problem was that when the Watergate scandal happened, and as I said, he wasn't involved in the Watergate scandal, for those who do not know, the Watergate scandal happened in the run-up to Nixon's re-election. Some people close to him broke into the Democratic National Committee headquarters to try to spy on the other candidate, basically. I'm skipping a lot of details, but no one's uncovered any evidence that Nixon knew about it in advance or authorized it. This was done by people close to him, but he hasn't been linked to the break-in. They broke in. They were very inept about it. It came out. What he has been implicated in is trying to cover it up. Well, as you can imagine, conversations about the break-in and about any potential efforts to cover it up, some of which may have taken place in the Oval Office. And when Congress found out that the Oval Office is recording everything said in there, they subpoenaed the tapes. And Nixon tried not to use executive privilege to keep from handing over the tapes. The Supreme Court did not side with him on that because it looked pretty clearly like he's not protecting national security or anything legitimate. He's just trying to protect himself from being found out. And when they listened to the tapes, there was an 18-minute blank spot that was just suspiciously right where it seemed like the conversation was getting interesting. His secretary swore up and down that she had just accidentally recorded over that part of the tape, but very few people believe that. Anyway, so executive privilege is unless it's being used to try to cover up potential wrongdoing, the courts have allowed it to, in order so that the president, nobody has to worry about saying what they really think when the president asks their opinion. Then there's more unofficial, the generally popularity, the people as a source of presidential power. That is maybe one of the biggest pieces of unofficial power that the president has, is his ability to get media attention, to get public to speak to the public, and to build public sentiment either for or against things. His power to persuade people to support the things he supports or to oppose the things he opposes. And there's a phrase attached with this the phrase that the president can use the bully pulpit. This phrase was originated by Theodore Roosevelt, and it should be noted that the word bully at the time, so Theodore Roosevelt became president in 1901, was inaugurated here in Buffalo, New York. Only time a president's been inaugurated anywhere outside of D.C. or outside the nation's capital, I should say. The word bully at that time does not mean what it means today. It meant good, splendid, superb. So what he was saying was that the presidency itself is a great pulpit, like platform or pulpit, like what preachers use, a great position from which to try to persuade people, to use the power of the attention that the presidency gets to try to persuade people to pay attention to the policies the president wants, to support positions that the president wants. So the president has a great position from which to get attention and to use that attention, to focus that attention on things that he thinks are important. And of course, approval ratings, we have talked about this before. The approval ratings are sort of a measure of how effective the president has been at persuading people. So when approval ratings tend to be especially high right after a president takes office, you will hear the phrase, I'm sure it will come up, of what is President Biden going to do during the first 100 days? The 100 days is it's an arbitrary sort of unit, but it has a nice ring to it. It refers to this honeymoon period, the early part of a president's term when, because he has just been elected, everyone seems more receptive to new ideas. So that is the time when presidents can usually get the most done. And so there will often be a big push to get a lot of proposals to Congress in that first 100 days, hoping to take advantage of that lingering glow of public approval from the election. Given this election, it'll be interesting to see how that goes. The other time that presidents tend to be particularly popular is when we've got some sort of threat or perceived threat to the country. They're called rally round the flag moments. So after the 9/11 attacks, the whole government got the approval rating shot up, but especially the president. When you've got some sort of a short-term military action, something that we can be seen as winning, that makes a president very popular. People like a winner. And so those times when presidents do something to make us feel justifiably or not proud to be American tend to make the president more popular. And then finally, technology and media. I've been talking about media as tools all along. That ability, that media has been the traditional way that the president has been able to use the bully pulpit. But now with new media, with social media, presidents can go directly to the people. And this has been interesting to me to watch over just the last two presidents. When President Obama came into office, there was like a huge controversy over whether they were going to let him keep his BlackBerry. By the time Trump comes into office, there was no question nobody was going to pry that man's cell phone out of his hands. Even when he's sending out tweets in the middle of the night that are really ill-advised and misspelled, you can go. Technology allows the president to communicate directly to people, and can be used as tools of influence. It can be questionable whether presidents on their own ought to be going so directly to people, that maybe they would be better advised to go through their communications staff to help polish their messages and make sure things like spelling are accurate so that they, don't embarrass themselves. But that ability, that new technology giving presidents the ability to communicate directly to the public without the mediation of the media, has become increasingly important, especially as people have grown to distrust the media and whether they are impartially actually representing what's going on.